Welcome to Middle Class Matters, Business News in English from Dr CMA Alagesan. Securities Exchange Board of India (SEBI) issues confirmatory order on Subash Chandra, the chairman, and Punit Goenka, the managing director, in the matter of ZEE Entertainment Enterprises Limited. Part 14 continued. 55. Drawing strength from the above set orders of the Honorable Supreme Court of India, I note that it has been prima facie found in the instant matter that the entities have used manipulative and deceptive devices as they have tried to obscure the fund trails to show that the six associate entities have actually used their own funds to pay ZEE Limited. The said manipulative and deceptive device was prima facie adapted by the entities to demonstrate that ZEE Limited had not incurred any loss by the liquidation of its fixed deposit by Yes Bank. Consequently, prima facie incorrect information was disclosed to the market, which would have hampered the investigators in having an informed opinion before dealing in the securities of ZEE Limited. Thus, the actions of the entities have led to market abuse, which is prima facie not in consonance with provisions of Regulation 41 of PFUTP Regulations 56. Further, as noted by the Honorable Supreme Court of India in the matter of Kanayalal Baldev Bhai Patel and the definition of fraud under PFUTP regulations has two parts, one catch-all provision and other specific instances. Thus, I note that the specific instances mentioned in the regulation 21C1 to 21CD C9 of PFUTP regulations would also constitute act of fraud even if there is no inducement to deal in securities, which is the requirement of the first part of the definition of fraud under regulation 21C of PFUTP regulations. Therefore, any act of knowing misrepresentation of the truth or concealment of material fact in order that another person may act to his detriment, or a suggestion as to a fact which is not true by one who does not believe it to be true, or an active concealment of a fact by a person having knowledge or belief of the fact, or deceptive behavior by a person depriving another of informed consent or full participation, or a false statement made without reasonable ground for believing it to be true, will also constitute fraud under PFUTP regulations. In the instant matter, it has been prima facie found that the entities had employed a scheme to show that the transfer of funds from six associate entities to ZEE Limited was genuine. Thus, prima facie, the entities have actively concealed a fact and have made a suggestion that ZEE Limited has suffered no loss in spite of having the knowledge that it is not true. Hence, their acts prima facie constitute fraud under PFUTP regulations and are prima facie in violation of regulations 4.1 of PFUTP regulations. 57. Moreover, post amendment, that is February 1, 2019, the definition of dealing in securities has been modified to include any act which may be knowingly designed to influence the decision of investors in securities. In the instant matter, the entities were prima facie involved in this scheme, which served two purposes. The first was to portray that ZEE Limited had incurred no loss due to the liquidation of its fixed deposit of INR 200 crore by Yes Bank in respect of dues of the seven associate entities, which are related parties of ZEE Limited, and second, the apparent repayment by the associate entities showed that the entities who, along with their family members, or the majority shareholders of the said associate entities which are privately held have not benefited from the liquidation of the fixed deposit of Z Limited, as the associate entities have repaid Z Limited from their own sources. However, prima facie finding of the interim order shows contrary to the opposite observation, which the entities have not been able to refute in the extant proceedings. Therefore, prima facie, it can be reasonably inferred that the whole scheme was orchestrated to prevent the shareholders as well as the investors in general from knowing that the entities have benefited at the expense of Z Limited. This implies that the management of Z Limited is not working in the best interest of the company or its public shareholders. The same will certainly influence the decision of the investors to invest in Z Limited securities. Hence, the submission that there was no dealing in securities by the entities is devoid of merit. The entity 58, the entities had also made the corporate announcement on October 17th, 2019 that the related parties have reimbursed the amount of INR 2019 crore to Z Limited. As noted above, prima facie, the related parties had not reimbursed Z Limited from their own resources. Rather than the funds were routed by Z Limited, its subsidiaries, and other listed companies of SL Group companies. Further, there is no material available on record to show that prima facie the information that the appropriation of Z Limited's fixed deposit by Yes Bank was inter alia triggered by LOC issued by entity number 1 was made known to the shareholders prior to its publication in the annual report. Hence, it is prima facie held that the entities have published false and incomplete information which has misled the shareholders and investors. Therefore, prima facie, the act of the entities qualifies as an unfair trade practice. It will be relevant here to quote from the order of the Honorable SAT in the matter of V. Natarajan vs. SEBI, decided on June 29, 2011, wherein it was held as follows. These regulations also prohibit persons from indulging in a fraudulent or unfair trade practice in securities, which includes publishing any information which is not true or which he does not believe it to be true. Any advertisement that is misleading or contains information in a distorted manner which may influence the decision of the investors is also an unfair trade practice in securities which is prohibited. The regulations also makes it clear that planting false or misleading news which may induce the public for selling or purchasing securities would also come within the ambit of unfair trade practices in securities. 59. The prima facie actions of the entities as discussed above have in effect resulted in diversion of assets of Z Limited to the benefit of the 7 associate entities and ultimately to the benefit of the members of the promoter family of Z Limited, including the entities who own or control the 7 associate entities. The same is squarely covered under the explanation of Regulation 4.1 of PFU-TP regulations. In view of the above, the entities are prima facie in violation of Regulations 4.1 of PFU-TP regulations. 60. Entities have also submitted that Regulation 4.2F of PFU-TP regulations uses the word knowingly, which means it is mandatory to establish mens rea to bring the violation of the said provision. On a perusal of the said provision, I do not concur with the submission made by the entities. It has been held by the Honorable Supreme Court of India in the matter of Kanayalal Baldev Patel Supra that to attract the rigor of Regulations 3 and 4 of the 2003 regulations, mens rea is not an indispensable requirement, and the correct test is one of preponderance of probabilities. Further, the word knowingly in the aforesaid regulation would mean that the person had the knowledge or that he was aware about a particular information that was not true but still went ahead and published it. I have already discussed in preceding paragraphs that the entities had prima facie orchestrated the scheme and hence they were aware that the corporate announcement that was made or published with respect to the reimbursement done by the associate entities was false, but still knowingly they caused the announcement to be published. Hence, their actions have prima facie violated regulations 4.2f of PFU TP regulations. 61. Further, the submission of the entities that the violations of PFU-TP regulations noted in the interim order are general in nature and do not make out any specific case is also untenable for the reason that the interim order has specifically mentioned that prima facie there is diversion of funds of ZEE Limited and misrepresentation in the annual report of ZEE Limited. Both the prima facie violations fall within the ambit of regulations 4.1 and 4.2f of PFU-TP regulations. Accordingly, I reject the submission of the entities in this regard. Other legal submissions made by the entities. 62. Before dealing with the submission of the entities with respect to the interior measures taken against them, I would like to address certain other legal submissions made by the entities before me. 63. Entities have argued that SEBI under section 11.1, 11.4 and 11b1 of the SEBI Act does not have the power to restrict or refrain any person to act or continue to act as a director or key managerial personnel in any listed company or its subsidiaries, and that the provisions of Companies Act 2013 govern the appointment and removal of director of a company. It has also been argued that the power of SEBI to regulate the affairs of companies under the Companies Act 2013 is only confined in Chapter 3, 4 and Section 127 of the Companies Act 2013 that dealt with prospectus and allotment of securities, share capital and debentures, and punishment for failure to distribute dividends, respectively. Further, since SEBI is neither a court nor a tribunal, for the purposes of the Companies Act, it cannot disqualify a person from acting as a director. Moreover, SEBI does not have any explicit powers under Section 11.4 of SEBI Act to restrain any person from acting as a director. 64. With regard to the above submissions, I note that under Section 11.1 of SEBI Act, SEBI has been in no uncertain terms mandated to protect the interest of the investors by such measures as it thinks fit. While the term measure has not been defined in the SEBI Act, a plain reading of the provisions makes it clear that the SEBI Act confers discretion on SEBI to take measures as it deems fit to achieve the objectives of the SEBI Act. Now the question arises as to whether such measures have any limitations. It goes without saying that SEBI has to regulate a multifaceted and dynamic market, and in such a market, varied situations, scenarios, and exigencies may arise. As and when new issue arises, they call for new solutions and measures. Thus, SEBI may take any course of action or measure that is best suited to address a particular situation. Therefore, any measure taken by SEBI to address a particular situation, so long as it is towards achieving the objective of investor protection and development of regulation of the securities market, would be within the authority of law. Though Section 11.4 of SEBI Act lists out certain specific measures that can be taken either pending investigation or inquiry or on completion of such investigation or inquiry, its provisions are without prejudice to the provisions contained in subsections 1, 2, 2A and 3 of Section 11 and Section 11B of SEBI Act. Thus, the provisions of Section 11B of SEBI Act are in addition to the measures that can be taken under Section 11(1) and 11B of SEBI Act, rather than circumferencing the scope of measures that can be taken under Section 11(1) and 11B of SEBI Act. In this context, it will be appropriate to quote the order of the Honorable SAT in the matter of Carvey Stock Broking Limited vs. SEBI, decided on January 8, 2007. In the said matter, it was held as follows. Please like the video, subscribe to the channel. Please share it to as many people as possible to spread the knowledge on the securities market and how the companies are manipulating to protect the investors' interest. Please spread it to your people who are also investing in equities market or debt market. Thanks for watching.